स्पष्ट करने हेतु अधिनियम में लचीलापन बनाए रखने हेतु Q3 केंद्र सरकार किन विषयों पर नियम बना सकती है? उत्तर
Section 61. Security for keeping the peace or for good behavior. Section 61 empowers a magistrate to require a person to give security, a bond, to maintain peace or good behavior when there is a reasonable fear that the person may disturb public order. Key points explained simply. When this power is used, if a magistrate receives information and believes that a person is likely to commit a breach of peace, disturb public order, or behave dangerously, the magistrate may act under this section. Order to show cause. The magistrate may issue an order asking the person to show cause why they should not be required to execute a bond with or without sureties. Nature of security. The bond is a promise backed by money or sureties that the person will keep the peace or maintain good behavior. The bond is required for a specified period decided by the magistrate. Preventive, not punitive. This section is preventive in nature, not a punishment for a past offense. What this means in practice. The law allows early intervention to prevent crimes before they occur. People who are likely to disturb peace can be legally restrained through bonds, not jail, unless they fail to comply. It balances public safety with individual liberty through judicial supervision. Section 62. Order to be made. Section 62 explains how magistrate must formally issue an order when requiring a person to give security for keeping the peace or for good behavior. Key points explained simply. Written order is mandatory. When a magistrate decides to act under Section 61, he must make a written order. Contents of the order. The order must clearly state the substance of the information received against the person, the amount of the bond to be executed, whether sureties are required, and if yes, how many, the period for which the bond will remain in force, clarity and fairness. The order must be clear and specific, so the person understands why the action is being taken and what is required of them. What this means in practice. A magistrate cannot act arbitrarily. Reasons and conditions must be clearly written. The person concerned gets proper notice and transparency. This section protects individuals by ensuring due process before demanding security. Section 63. Procedure in respect of person present in court. Section 63 explains the procedure a magistrate must follow when the person against whom action is proposed is already present in court. Key points explained simply. Order to be read or explained. When the person is present in court, the magistrate must read out the order made under Section 62 to them or clearly explain its contents. Opportunity to respond. The person must be given a chance to show cause, give reasons or explanation as to why they should not be ordered to execute the bond for keeping the peace or good behavior. Fair hearing. The magistrate must hear the person's explanation before deciding whether to require security. What this means in practice. The person gets immediate knowledge of the allegations and requirements. They are given a fair opportunity to defend themselves. This ensures natural justice and due process before imposing any preventive conditions. Section 64. Summons or warrant in case of person not present in court. Section 64 explains what a magistrate should do if the person against whom preventive action is proposed is not present in court. Key points explained simply. Issue of summons. If the magistrate believes the person's presence can be secured peacefully, he may issue a summons requiring the person to appear before the court. Issue of warrant if necessary. If the magistrate believes that a summons is not sufficient or that the person may not obey it, he may issue a warrant for arrest. Purpose of appearance. The person is required to appear so that the magistrate can read or explain the order under Section 62 and give the person an opportunity to show cause. What this means in practice. The law prefers summons over arrest, promoting minimal interference with personal liberty. Arrest is used only when necessary. This ensures fairness and proportionality in preventive proceedings. Section 65. Copy of order to accompany summons or warrant. Section 65 ensures that a person clearly knows why they are being called to court or arrested in preventive proceedings. Key points explained simply. Order must be attached. Every summons or warrant issued under Section 64 must be accompanied by a copy of the magistrate's order made under Section 62. Informing the person properly. The copy of the order informs the person about the allegations or information against them, the amount of bond, number of sureties, and the period for which security is demanded. Transparency and fairness. This prevents the person from being summoned or arrested without knowing the reasons. What this means in practice. No one can be called or arrested blindly in preventive proceedings. The person gets full prior information to prepare their explanation or defense. This section strengthens natural justice and due process. Section 66. Power to dispense with personal attendance. Section 66 gives a magistrate the discretion to excuse a person from appearing in person in preventive proceedings if personal attendance is not necessary. Key points explained simply. Exemption from personal appearance. The magistrate may permit the person to appear through a lawyer instead of appearing personally. Conditions for exemption. This can be allowed when personal attendance would cause unnecessary hardship, or the ends of justice do not require the person's physical presence. Magistrate's control remains. Even after granting exemption, the magistrate may later require personal attendance if it becomes necessary. What this means in practice. Preventive proceedings are made less burdensome, especially for elderly, ill, or distant persons. The magistrate maintains full control and flexibility over the proceedings. This section balances convenience with judicial supervision. Section 67. Inquiry as to truth of information. Section 67 explains that when a person appears before the magistrate or is brought before him in preventive proceedings, the magistrate must inquire into the truth of the information on which action was initiated. Key points explained simply. Inquiry by magistrate. The magistrate must examine whether the information received is true and whether there is a real need to require the person to give security. Evidence is considered. During the inquiry, the magistrate may hear witnesses, examine documents, and consider any other relevant evidence. Opportunity to the person concerned. The person against whom action is taken has the right to participate in the inquiry, challenge the evidence, and present their own explanation or defense. Procedures similar to trial. Summary. The inquiry generally follows procedures similar to a trial of summons cases, but it is preventive, not punitive. What this means in practice. A person cannot be forced to give security without proof or proper inquiry. The magistrate must apply judicial mind, not act mechanically. This section ensures fairness, natural justice, and protection of personal liberty. Section 68. Order to give security. Section 68 explains what the magistrate must do after completing the inquiry under Section 67. Key points explained simply. Order after inquiry. If, after inquiry, the magistrate is satisfied that it is necessary for the person to keep the peace or maintain good behavior, the magistrate shall make an order requiring the person to give security. Details of the security order. The order will specify the amount of the bond, the number and nature of sureties, if required, and the period for which the security must remain in force. If inquiry does not justify action, if the magistrate finds no sufficient ground, the proceedings must be closed and the person is discharged. What this means in practice: a person is required to give security only after proper judicial inquiry. Preventive action is taken only when genuinely needed to protect public peace. This section ensures that liberty is not restricted without justification. Section 69. Commencement of period for which security is required. Section 69 explains from which date the security bond becomes effective and how the period of the bond is calculated. Key points explained simply. When the bond period starts, the period for which a person is required to give security begins from the date on which the bond is executed, signed, and accepted by the magistrate. If the person is sent to prison, if the person fails to give security and is sent to prison, the period of security will start from the date of release from prison, not from the date of the original order. Fair calculation of time. This ensures that the person actually gets the full benefit of the bond period instead of losing time while in custody. What this means in practice: a bond is meaningful only after it is executed. Time spent in jail for failure to furnish security does not reduce the bond period. This prevents unfair shortening of the security obligation. Section 70. Contents of bond. Section 70 explains what a security bond must contain when a person is ordered to give security for keeping the peace or good behavior. Key points explained simply. Clear conditions in the bond. The bond must clearly state that the person will keep the peace or will maintain good behavior for the specified period. Amount and sureties. The bond must mention the amount of money involved and the number and details of sureties if sureties are required. Binding legal obligation. By signing the bond, the person legally promises to follow the conditions. Any violation of the bond can lead to legal consequences, including forfeiture of the bond amount. What this means in practice: a bond is not a mere formality, it is a serious legal commitment. Clear wording prevents confusion or misuse. This section ensures certainty, enforceability, and fairness in preventive proceedings. Section 71. Power to reject sureties. Section 71 gives the magistrate the authority to accept or reject sureties offered by a person who is required to give a security bond. Key points explained simply. Court's discretion over sureties. When a person offers sureties, people who guarantee compliance with the bond, the magistrate may examine whether the sureties are suitable. Rejection of unfit sureties. The magistrate can reject a surety if he believes that the surety is unreliable, incapable of fulfilling the obligation, or unsuitable for any valid legal reason. Reasoned decision. The magistrate should act judicially and fairly, not arbitrarily, while accepting or rejecting sureties. What this means in practice. Not every person can automatically act as a surety. Courts ensure that sureties are genuine and capable, so the bond has real value. This protects the effectiveness of preventive justice. Section 72. Imprisonment in default of security. Section 72 explains what happens if a person fails to give the required security, bond, or sureties as ordered by the magistrate. Key points explained simply. Failure to furnish security. If a person does not give the bond or produce acceptable sureties as ordered under sections 68-71, the magistrate may commit the person to prison. Duration of imprisonment. The person may be kept in prison for the period for which the security was required or until the security is furnished. Whichever happens first. Not a punishment for an offense. This imprisonment is preventive, not punitive. The person is not being punished for a crime, but is detained because they failed to comply with a lawful preventive order. What this means in practice. Giving security is optional, but refusing it can lead to loss of liberty. The person can secure release at any time by furnishing the required bond or sureties. This section ensures that preventive orders are effective while still allowing release upon compliance. Section 73. Power to release person imprisoned for default of security. Section 73 gives the magistrate the power to release a person who has been imprisoned for failing to furnish security if circumstances justify such release. Key points explained simply. Release after furnishing security. A person imprisoned under Section 72 must be released immediately once they furnish the required security or bond. Discretionary release. Even if the person has not yet furnished security, the magistrate may reduce the amount of security or modify the conditions or order release if justice so requires. Judicial control. The power is exercised judicially, considering the person's conduct, change in circumstances, or interest of justice. What this means in practice: imprisonment for default of security is not permanent. The law allows flexibility and fairness, preventing unnecessary detention. Magistrates can adapt orders to ensure justice without harshness. Section 74. Discharge of sureties. Section 74 explains how and when a surety can be released, discharged, from their responsibility under a security bond. Key points explained simply. Surety can apply for discharge. A person who has given surety for another person may apply to the magistrate to be discharged from the bond. Issue of summons or warrant. On such application, the magistrate may issue a summons to the person for whom the surety was given, or issue a warrant if necessary to bring that person before the court. Fresh security required. Once the surety is discharged, the magistrate may require the person to furnish fresh security. If the person fails to give new security, the magistrate may commit the person to prison until security is furnished or the period expires. What this means in practice: a surety is not bound forever and can legally withdraw responsibility. The court ensures that public safety is not compromised by demanding fresh security. This section balances the rights of the surety with the preventive purpose of the law. Section 75. Forfeiture of bond. Section 75 explains what happens when a bond is broken, that is, when the person bound by the bond fails to follow its conditions, such as keeping the peace or maintaining good behavior. Key points explained simply. Bond breach leads to forfeiture. If the court is satisfied that the conditions of the bond have been violated, it may declare the bond forfeited. Recording reasons. The court must record the reasons in writing for declaring the bond forfeited. This ensures fairness and transparency. Recovery of bond amount. After forfeiture, the court may recover the bond amount from the person bound by the bond, or recover it from the sureties, if any. Imprisonment in default of payment. If the bond amount cannot be recovered, the court may order imprisonment for a prescribed period as per law. What this means in practice: a bond is a serious legal commitment. Violating bond conditions can lead to financial loss and even loss of liberty. Courts must act judicially and with reasons, protecting against arbitrary action. Section 76. Cancellation or remission of forfeited bond. Section 76 gives the court the power to cancel or reduce, remit, the amount of a bond that has been forfeited, either fully or partially. Key points explained simply. Court's discretionary power. When a bond has been forfeited under Section 75, the court may cancel the forfeiture or reduce, remit the whole or part of the bond amount. Reasons for remission. The court may consider the nature of the breach, the conduct of the person or surety, whether the breach was minor or unintentional, and the interests of justice. Benefit to sureties as well. This relief can apply both to the person bound by the bond and to the sureties. What this means in practice. Forfeiture is not always final or harsh. Courts can show leniency where justified, especially in technical or minor breaches. This section ensures fairness and proportionality in enforcing bond conditions. Section 77. Appeal against orders under security proceedings. Section 77 gives a person the right to appeal against certain orders passed by a magistrate in preventive security proceedings. Key points explained simply. Right to appeal. Any person who is aggrieved by an order passed under the security-related provisions, such as orders requiring security, imprisonment in default, forfeiture, etc., may file an appeal. Appellate authority. The appeal lies to the Sessions Court or the appropriate higher court as prescribed. Judicial review of magistrate's order. The appellate court may confirm the order, modify the order, or set aside the order, depending on legality, facts, and justice. Safeguard against misuse. This section ensures that preventive powers of magistrates are subject to higher judicial scrutiny. What this means in practice. Preventive orders are not final or unquestionable. Affected persons have a legal remedy if they believe the magistrate's order is unfair or unlawful. This strengthens fairness, accountability, and protection of personal liberty. Section 78. Power of magistrate to proceed against persons present in court. Section 78 allows a magistrate to take immediate preventive action against a person who is present in court if the magistrate believes that such person is likely to disturb public peace or commit an offense. Key points explained simply. Immediate action in court. If a person is already present before the magistrate need not issue a summons or warrant. Preventive power. The magistrate may start proceedings on the spot under the preventive provisions, security for peace or good behavior. Reasonable belief required. The magistrate must have sufficient grounds to believe that action is necessary to prevent breach of peace or disorder. Procedure still applies. Even though action is immediate, the magistrate must still follow due process, explain the order, allow hearing, inquiry, etc. What this means in practice: courts can act swiftly to prevent disturbances when risk is obvious. People cannot misuse court presence to avoid preventive action. At the same time, legal safeguards and fairness remain intact. Section 79. Proceedings against habitual offenders. Section 79 empowers a magistrate to take preventive action against habitual offenders or persons who repeatedly engage in criminal or dangerous activities. Key points explained simply. Who can be proceeded against? A person who is habitually involved in offences such as theft, robbery, cheating. Offences involving violence. Offences affecting public peace, or any repeated criminal behavior that threatens society. Requirement of security for good behavior. The magistrate may order such a person to execute a bond for good behavior with or without sureties. Preventive, not punitive. The action is not a punishment for past crimes. It is taken to prevent future offences and protect public safety. Procedure and safeguards. The magistrate must follow due process, inquiry, and opportunity of hearing before passing any final order. What this means in practice: law targets repeat offenders, not ordinary citizens. The aim is to stop ongoing criminal tendencies before serious harm occurs. Judicial supervision ensures fairness and protection of individual liberty. Section 80. Security for good behavior from persons disseminating harmful information. Section 80 empowers a magistrate to take preventive action against a person who is spreading false, alarming, or harmful information that is likely to disturb public peace or create fear among the public. Key points explained simply. Who can be proceeded against? A person who spreads false rumors, circulates alarming or misleading information, or communicates material likely to cause panic, public disorder, or disturbance of peace. Order for security for good behavior. The magistrate may require such a person to execute a bond for good behavior with or without sureties. Preventive nature. The action is not punishment for an offense already committed. It is taken to prevent future harm to public order. Procedure and safeguards. Before passing a final order, the magistrate must follow proper procedure, inquiry into facts, and opportunity of hearing to the person concerned. What this means in practice. This section helps authorities control rumors, misinformation, and panic, especially in sensitive situations. It balances public order with freedom of expression by requiring judicial oversight. Action can be taken before serious damage occurs, but only through lawful process. Section 81. Period for which security for good behavior may be required. Section 81 fixes the maximum time limit for which a person can be required to give security, bond, for good behavior under the preventive provisions of BNSS. Key points explained simply. Maximum duration. The security for good behavior cannot exceed 3 years. Applies to preventive proceedings. This limit applies to bonds ordered under provisions like proceedings against habitual offenders or persons likely to disturb public peace or spread harmful information. Judicial control. The magistrate must clearly mention the period in the order. The period must be reasonable and justified based on facts of the case. What this means in practice. Preventive control over a person's conduct cannot be indefinite. The law ensures a clear outer limit to protect personal liberty. Magistrates must balance public safety with individual rights. Section 82. Effect of conviction on security for good behavior. Section 82 explains what happens to a security bond for good behavior if the person is later convicted of an offense during the period of the bond. Key points explained simply. Conviction during bond period. If a person who has given security for good behavior is convicted of an offense during the time the bond is in force, the court may take action. Bond may be cancelled or forfeited. The magistrate may cancel the bond or forfeit the bond wholly or partly, depending on the nature of the offense and circumstances. Fresh proceedings possible. The conviction can also be treated as new material to start fresh preventive proceedings if necessary. Judicial discretion. The magistrate must act judicially, considering the seriousness of the offense and whether the conviction shows a breach of good behavior. What this means in practice. A bond for good behavior is a serious obligation. Committing an offense during the bond period can lead to loss of bond amount and further legal action. This section ensures that preventive measures remain effective and meaningful. Section 83. Procedure on completion or termination of security proceedings. Section 83 explains what happens after security proceedings come to an end, either because the period of the bond has expired or The magistrate decides to terminate the proceedings. Key points explained simply. Proceedings come to an end. When the bond period expires, or when the magistrate finds that security is no longer required. The proceedings are closed. Discharge of person and sureties. The person who gave the bond and the sureties are discharged from their obligations. They are no longer legally bound by the bond conditions. No further liability. Once proceedings are terminated lawfully, no action can be taken under that bond for future conduct. What this means in practice. Preventive control under BNSS is temporary, not permanent. Once the legal purpose is served, personal liberty is fully restored. This section ensures certainty and closure in preventive proceedings. Section 84. Local jurisdiction of magistrates. Section 84 explains which magistrate has the authority, jurisdiction, to conduct preventive proceedings for security, for peace, or good behavior. Key points explained simply. Jurisdiction based on residence or activity. Preventive proceedings may be initiated by a magistrate. Where the person resides, or where the person is present, or where the person is likely to commit a breach of peace or offense. Flexibility in jurisdiction. The law allows action even if the person's dangerous activity is outside the place of residence, as long as there is a real connection. Preventive purpose. This flexibility ensures that public safety is protected effectively without being blocked by technical jurisdiction issues. What this means in practice. A person cannot escape preventive action simply by living in another area. Magistrates can act where the threat actually exists. This ensures timely and effective preventive justice. Section 85. Persons present in one district committing acts in another. Section 85 deals with situations where a person is physically present in one district, but their acts, behavior, or influence affect peace or safety in another district. Key points explained simply. Preventive action across districts. If a person is present in one district, but their actions are causing or are likely to cause a breach of peace or disturbance in another district, a magistrate can still take preventive action. Which magistrate can act? The magistrate of the district, where the person is present, or where the harmful acts are occurring or likely to occur, may initiate proceedings. No escape through technicalities. A person cannot avoid preventive proceedings by operating from a different district while affecting public order elsewhere. What this means in practice. Preventive justice focuses on real impact, not just physical location. Authorities can act against cross-district troublemakers, including those spreading threats, planning violence, or coordinating unlawful acts remotely. This strengthens public order and safety while remaining under judicial control. Section 86. Action in cases where jurisdiction is uncertain. Section 86 deals with situations where it is unclear which magistrate has local jurisdiction to take preventive action. Key points explained simply. Uncertainty about jurisdiction. When there is doubt or dispute about which area or district has jurisdiction over a person or incident, this section applies. Any competent magistrate may act. A magistrate who believes he has jurisdiction may start preventive proceedings temporarily so that public peace is not endangered. Resolution of jurisdiction. Once it becomes clear which magistrate actually has jurisdiction, the proceedings may be continued by that magistrate or transferred appropriately. Preventive priority. The law prioritizes immediate preventive action over technical delays caused by jurisdictional confusion. What this means in practice. Preventive justice should not fail because of technical doubts about jurisdiction. Magistrates can act quickly to prevent danger and sort out jurisdiction later. This ensures public safety while maintaining judicial order and fairness. Section 87. Procedure where jurisdiction is finally determined. Section 87 explains what must be done after it is finally decided which magistrate has proper jurisdiction in preventive proceedings. Key points explained simply. Transfer to the proper magistrate. When it is clearly determined which magistrate has jurisdiction, the case must be transferred to that magistrate. Continuation of proceedings. The magistrate who finally gets jurisdiction may continue the proceedings from the stage already reached or re-examine or redo any part of the proceedings if justice requires. Validity of earlier actions. Actions already taken by the previous magistrate do not become invalid automatically just because jurisdiction was uncertain earlier. What this means in practice. Preventive proceedings are not wasted or cancelled due to jurisdictional confusion. Public safety measures taken earlier remain effective. Final control rests with a properly authorized magistrate, ensuring legality and fairness. Section 88. Procedure in cases of urgent necessity. Section 88 gives a magistrate special powers in urgent situations where there is an immediate danger to public peace or safety, and waiting for the normal procedure would cause harm. Key points explained simply. Immediate preventive action. If a magistrate believes that there is an urgent risk of breach of peace, disturbance, or danger to life or property, he may take immediate action. Interim order for security. The magistrate may direct the person to execute a bond immediately, even before completing the full inquiry required under earlier sections. Temporary nature of the order. Such an order is interim, temporary. The magistrate must complete the regular inquiry as soon as possible afterward. Protection of public interest. This power is meant to prevent imminent harm, not to punish. What this means in practice. The law allows quick intervention when delay could lead to violence or serious disorder. Even in urgency, judicial oversight remains, and the person still gets a full hearing later. This section balances public safety with individual rights. Section 89. Consequences of failure to give security in urgent cases. Section 89 explains what happens if a person does not comply with an urgent order to give security made under Section 88. Key points explained simply. Failure to comply with urgent order. If a person fails or refuses to execute the bond required by an urgent interim order, the magistrate may take action. Detention until compliance or inquiry completion. The magistrate may detain the person in custody until the person furnishes the required security or the regular inquiry is completed, whichever happens earlier. Preventive, not punitive. This detention is not a punishment. It is meant only to prevent immediate danger to public peace or safety. What this means in practice. Urgent preventive orders must be obeyed immediately. If someone refuses, the law allows temporary detention to avert imminent harm. At the same time, the magistrate must complete the normal inquiry promptly, ensuring fairness. Section 90. Completion of inquiry and final order after urgent proceedings. Section 90 explains what the magistrate must do after taking urgent preventive action under Sections 88 and 89. Key points explained simply. Inquiry must be completed. Even when urgent action has been taken, the magistrate must complete the regular inquiry as required under earlier sections, like Section 67. Final decision by magistrate. After completing the inquiry, the magistrate must decide whether the person should be finally ordered to give security or the proceedings should be dropped and the person discharged. Effect on detention. If the magistrate decides that security is not required, any detention or interim order must immediately end. If security is required, the order continues as per law. Judicial safeguard. Urgent powers are temporary and cannot replace the full legal process. What this means in practice. Emergency powers do not bypass due process. Every person is entitled to a full inquiry and reasoned decision. This section ensures a balance between urgent public safety and individual liberty. Section 91. Summons to produce document or other thing. Section 91 gives courts and police officers the legal power to require a person to produce documents, records, or any other thing that is necessary for investigation, inquiry, trial, or other proceedings. Key points explained simply. Who can issue the order? A court or an officer in charge of a police station may issue a written summons or order. What can be demanded? Any document, record, electronic data, or object that is necessary or desirable for the purposes of investigation or court proceedings. How compliance can be done. The person required to produce the item may attend personally and produce it, or send it through another person if allowed by the order. No automatic seizure. This section is about production, not seizure. Seizure requires separate legal authority. What this means in practice. Courts and police can lawfully access important evidence like documents, mobile records, bank records, CCTV footage, etc. A person cannot refuse to produce required material without lawful excuse. This section ensures effective investigation while following due process. Section 92. Procedure for production of postal, telegraph, or electronic records. Section 92 lays down the special procedure for calling and producing documents or records that are in the custody of postal, telegraph, or electronic communication authorities. Key points explained simply. Who can issue the order? Only a district magistrate, chief judicial magistrate, court of session, or high court can issue an order under this section. What records can be demanded? Records relating to postal articles, telegraph messages, or electronic communications, such as call records, digital data, etc. How the records are produced. The authority holding such records must produce them before the court, or allow inspection of the records as directed. Protection of privacy. Because these records involve private communications, they can be accessed only through higher judicial authority, not by ordinary police orders. What this means in practice. Sensitive communication data cannot be demanded casually. Judicial oversight ensures a balance between investigation needs and individual privacy. This section is especially important in cases involving telecom data, emails, digital messages, and postal records. Section 93. Search warrant. Section 93 gives courts the power to issue a search warrant to search a place for evidence, documents, or things necessary for an investigation, inquiry, or trial. Key points explained simply. Who can issue a search warrant? A magistrate or any other authorized court can issue a warrant. When it can be issued? When there is reason to believe that a person is hiding evidence, possesses documents or things related to an offense, or may destroy or tamper with evidence. Form of the warrant. The warrant must be in writing and specify. Place to be searched. Person or things sought and purpose of the search. Execution of the warrant. Police or authorized officials may enter the premises and search, if necessary, using reasonable force. Respect for privacy and dignity. Searches must be conducted lawfully and respectfully, especially in residential premises. What this means in practice. Courts can ensure evidence is not destroyed or hidden. A search is legal only with a proper warrant, preventing arbitrary action. This section protects both investigation needs and personal rights. Section 94. Summons or search for objects in possession of third parties. Section 94 allows a magistrate or authorized officer to call for documents, records, or objects from someone who is not directly accused but has possession of material relevant to an investigation or court proceeding. Key points explained simply. Third-party possession. The section applies when a person other than the accused holds documents, records, or objects that are important for investigation, inquiry, or trial. Legal summons or search. The court or officer can issue a summons requiring the person to produce the item or issue a search warrant to recover the item if necessary. Purpose of the order. To ensure all relevant evidence is available, even if it is in the hands of third parties. Protection of rights. Third parties must comply with lawful orders, but the search or seizure must respect dignity and privacy, as with any search. What this means in practice. Investigators can access critical evidence, even if it is not directly held by the accused. Courts can prevent obstruction of justice by people who might otherwise withhold evidence. balances investigation needs with rights of innocent persons. Section 95. Seizure of property during search. Section 95 gives authority to the police or authorized officer to seize documents, records, or other property found during a search if it is relevant to an investigation, inquiry, or trial. Key points explained simply. Property subject to seizure. Any document, record, electronic device, or other object that may be evidence of an offense or is likely to be destroyed, tampered with, or hidden can be seized. Legal procedure. The seizure must be done under lawful authority, usually by magistrate's order or warrant issued under sections 93-94. Recording the seizure. A written list of seized items must be prepared and signed by the officer conducting the seizure and a witness if available. Custody of seized property. Seized items must be kept safely until required for investigation or court proceedings. If the property is not needed, it should be returned promptly. What this means in practice. Seizure ensures evidence is preserved and available for legal proceedings. Prevents destruction or concealment of crucial material. Ensures transparency and accountability through proper recording and custody. Section 96. Power to take photographs, fingerprints, or measurements. Section 96 allows police officers or authorized authorities to collect physical identifiers of a person during an investigation or preventive proceeding. Key points explained simply. What can be taken? The officer may take photographs, fingerprints, measurements such as height, hair, body marks, or other identifying features. Who can be subjected to this? Any person who is lawfully arrested or required to give security or otherwise relevant to an investigation or preventive proceeding. Purpose of taking identifiers. To confirm identity. To maintain accurate records and to assist in future investigation or legal proceedings. Respect for privacy and dignity. Procedures must be conducted respectfully and in a manner that does not cause unnecessary harm or humiliation. What this means in practice. Ensures reliable identification of suspects or persons subject to preventive action. Helps track habitual offenders or prevent false identity claims. Provides legal documentation for courts and police without violating rights if done properly. Section 97. Power to require attendance of persons and production of things. Section 97 allows a magistrate or authorized officer to require a person to attend and produce documents, records, or other objects relevant to an investigation, inquiry, or court proceeding. Key points explained simply. Who can be required to attend? Any person who is believed to have information, documents, or objects useful for investigation or proceedings. What can be required to produce? Documents, records, electronic data, or other items relevant to investigation of an offense, preventive proceedings, or court inquiry. Form of requirement. The order is usually a written summons specifying date, time, and place of attendance and specific items or information to be produced. Legal obligation. The person must comply unless they have a valid legal reason not to do so. What this means in practice. Ensures all relevant evidence and information is available to authorities. Helps prevent obstruction of justice by third parties. Balances investigation needs with legal safeguards for individuals. Section 98. Consequences of failing to comply with order under Section 97. Section 98 explains what happens if a person refuses or fails to comply with a lawful order to attend or produce documents or things under Section 97. Key points explained simply. Failure to comply. If a person does not attend or does not produce the required items without a valid reason, the magistrate or court may take action. Power of detention or coercion. The court may order detention of the person until they comply, or take other measures necessary to enforce the order. Protective limits. The detention or coercive measures are only to ensure compliance, not as punishment. Once the person complies, they must be released immediately. Judicial discretion. The court may consider the reason for non-compliance, the urgency and importance of the material, and act proportionately. What this means in practice. Orders under Section 97 must be obeyed, otherwise legal enforcement follows. This ensures that evidence and information are not withheld, aiding investigation and court proceedings. The law protects individual rights as enforcement is coercive, not punitive, and temporary. Section 99. Power to issue summons or warrants for witnesses. Section 99 gives the magistrate or court the authority to summon witnesses or issue warrants to compel their attendance in an investigation, inquiry, or trial. Key points explained simply. Who can be summoned? Any person who is believed to have information relevant to the case or can testify about the facts related to the offense or preventive proceedings. Forms of compelling attendance. The court may issue a summons, request to attend voluntarily, or issue a warrant to compel attendance if the person is likely to ignore the summons. Legal obligation. Witnesses must comply with the summons or warrant unless they have a valid legal exemption. Scope of the power. This applies to criminal trials, investigations, and preventive proceedings under BNSS. What this means in practice. Courts and police can ensure attendance of all relevant witnesses. Helps collect full and accurate evidence. Provides a legal mechanism to prevent obstruction in investigations or trials. Section 100. Execution of summons or warrants issued under Section 99. Section 100 explains how a summons or warrant issued to a witness under Section 99 should be executed by the authorities. Key points explained simply. Service of summons. A summons must be personally delivered to the witness, or if personal service is not possible, delivered in a lawful manner so the witness knows about it. Execution of warrants. If the witness fails to comply with the summons, the court may issue a warrant to bring them forcibly. Authorized officers can arrest and produce the witness before the court. Documentation. Officers executing the summons or warrant must record the steps taken, including date, time, and place of service, and details of the witness's response. Respect for rights. Execution must be done lawfully and respectfully, without unnecessary force or harassment. What this means in practice. Ensures witnesses appear in court and provide evidence. Prevents witnesses from ignoring lawful summons. Balances the authority of the court with protection of individual rights during enforcement. Section 101. Summoning public servants or officials. Section 101 allows a magistrate or court to summon government officials or public servants to provide evidence or documents for an investigation, inquiry, or trial. Key points explained simply. Who can be summoned? Any public servant or official who may have information about an offense or hold documents, records, or other material relevant to a case. Legal obligation. Public servants must comply with the summons, just like ordinary witnesses. Failure to comply may result in penal consequences under the law. Purpose: ensures that official records and information held by the government are accessible for investigation and justice. Protection for public servants: the law protects them from unnecessary harassment, ensuring they comply only as required by law. What this means in practice: courts can legally access records or evidence held by government offices. Public servants cannot refuse lawful requests for information. This helps ensure investigations and trials are thorough and accurate. Section 102. Summoning or examining persons in special cases. Section 102 gives the magistrate or court the power to summon or examine persons who may have special knowledge, technical expertise, or relevant information, even if they are not regular witnesses. Key points explained simply. Who can be summoned? Experts, technical personnel, or any person who has special knowledge relevant to the investigation or case. Purpose of summoning: to provide expert opinions, technical details, or other relevant information that can assist the court in understanding the matter. Legal obligation: the summoned person must attend and give evidence as required by the court. Failure to comply may be treated as contempt of court or other legal consequences. Respect and fairness: the court must ensure that such persons are treated fairly, especially when their attendance may cause inconvenience. What this means in practice: courts can call technical or expert evidence to aid justice. Investigations are not limited to ordinary witnesses. Expert knowledge can be formally included. Ensures that complex cases are decided with full and accurate information. Section 103. Power to inspect places or objects relevant to investigation or trial. Section 103 allows a magistrate or authorized officer to inspect any place or object that is relevant to an investigation, inquiry, or trial. Key points explained simply. What can be inspected? Any place, building, premises, or object that may provide evidence of an offense or is relevant for preventive proceedings. Who can authorize inspection? A magistrate or an officer authorized by law can conduct or order the inspection. Purpose of inspection: to examine conditions, collect evidence, or verify facts directly from the scene. Documentation: officers conducting the inspection must record their observations and may take photographs, measurements, or notes for official records. Respect for rights: inspection must be conducted lawfully, without unnecessary damage, and respecting privacy and dignity. What this means in practice: helps the authorities understand the scene or object related to the offense or preventive action. provides direct evidence to strengthen investigations and judicial decisions, balances effective law enforcement with individual rights. Section 104, recording evidence obtained during inspection or investigation. Section 104 explains how evidence obtained during inspection, search, or investigation must be formally recorded for use in court or preventive proceedings. Key points explained simply. Evidence must be recorded. Any observations, documents, measurements, or items obtained during inspection or investigation must be recorded in writing. Contents of the record. The record should include date, time, and place of inspection, names of persons present, details of items examined or collected, observations made by the officer or magistrate, signatures. The record should be signed by the officer conducting the inspection and, where possible, by witnesses present. Use in legal proceedings. Properly recorded evidence can be used in court to prove facts or support preventive measures. Transparency and accountability. Recording ensures that actions taken by authorities are documented and can be reviewed for legality. What this means in practice. Evidence obtained during searches or inspections is officially documented, making it admissible and reliable in court. Protects both the investigation process and the rights of affected persons. Ensures transparency, accountability, and proper judicial oversight. Section 105, Power to examine persons acquainted with facts of the case. Section 105 allows a magistrate or authorized officer to examine anyone who has personal knowledge of facts relevant to an investigation, inquiry, or trial. Key points explained simply. Who can be examined? Any person who is believed to have direct knowledge of events, actions, or circumstances related to the offense or preventive proceeding. Purpose of examination. To clarify facts, gather testimony, and assist the court or police in understanding the case accurately. Mode of examination. The examination is conducted under oath or affirmation when required. Proper records of the questions and answers must be kept. Obligation to cooperate. Persons who are summoned or requested to give evidence must cooperate unless they have a lawful excuse. Use in proceedings. The recorded testimony can be used as evidence during trials or preventive proceedings. What this means in practice. Ensures that eyewitnesses or knowledgeable persons are properly examined. Helps authorities establish facts and evidence reliably. balances the need for investigation with the rights of individuals. Section 106. Summoning persons in custody or detained elsewhere. Section 106 allows a magistrate or authorized officer to summon a person who is already in custody or detained elsewhere so that they can be examined for an investigation, inquiry, or trial. Key points explained simply. Who can be summoned? Any person who is in police custody, jail, or detained in another place and is believed to have relevant knowledge about the case. Purpose of summoning: to examine them as a witness or to obtain information necessary for investigation or preventive proceedings. Procedure: the magistrate may issue a summons or order to bring the person before the court or authorized officer. Transportation and security are arranged lawfully, ensuring safe custody during transfer. Rights of the person summoned: the person has the same rights as any other witness, including the right to legal representation if allowed by law. What this means in practice: ensures that even detained individuals can provide relevant evidence or testimony. Prevents gaps in investigation caused by witnesses or knowledgeable persons being in custody elsewhere. Balances effective justice with protection of rights of the person summoned. Section 107. Procedure for recording statements of persons examined under Sections 105 and 106. Section 107 explains how the statements of persons examined under Sections 105 and 106 should be formally recorded and documented for use in investigation or trial. Key points explained simply. Recording of statements. Statements given by persons examined under Sections 105, persons acquainted with facts, and 106, persons in custody elsewhere, must be recorded in writing. Details to be included. The record should include date, time, and place of examination. Identity of the person examined. Questions asked and answers given. Names of persons present, if any. Signatures and authentication. The record should be signed by the officer or magistrate recording it. The person giving the statement should also sign or mark the record, if possible. Use in proceedings. Properly recorded statements can be used as evidence in investigation, preventive proceedings, or trial. What this means in practice: ensures accurate documentation of witness testimony. Protects both the rights of the witness and the integrity of the investigation. Makes statements admissible and credible in court. Section 108. Power to require persons to give information or produce documents for investigation. Section 108 allows a magistrate or authorized officer to require any person to provide information, documents, or other material relevant to an investigation or inquiry. Key points explained simply. Who can be required? Any person who is believed to have knowledge or possession of information, records, or items important for the investigation. Nature of requirement. The officer may require the person to answer questions or produce documents, records, or other relevant objects. Form of request. Usually, the requirement is issued as a written notice or order, clearly stating what information or documents are needed and the time and place for compliance. Legal obligation. The person must comply unless there is a valid legal excuse, such as privilege under law. Protection of rights. The person providing information is protected against harassment, and the request must be reasonable and lawful. What this means in practice. Ensures that authorities can collect all necessary information and documents for proper investigation. Prevents people from withholding crucial evidence. Balances investigative needs with individual rights and legal safeguards. Section 109. Inspection of documents or property produced under Section 108. Section 109 explains how authorities may inspect documents, records, or property that a person has been required to produce under Section 108. Key points explained simply. Inspection by authorized person. The magistrate or officer who requested the information or documents under Section 108 may inspect the produced items. Purpose of inspection. 2. Verify authenticity. Take notes or copies, or examine items for relevance to the investigation or proceedings. Documentation of inspection. The inspection should be properly recorded, mentioning items inspected, date and place, observations made during inspection, respect for property and rights. The inspection must be conducted lawfully, without unnecessary damage, and respecting privacy. What this means in practice. Authorities can examine evidence provided to ensure it is complete and relevant. Maintains transparency and accountability in handling documents or property. Protects the rights of the person producing the items while supporting investigation or trial. Section 110. Power to examine accused persons or persons connected with the offense. Section 110 allows a magistrate or authorized officer to examine the accused or any person connected with the offense to collect information or evidence for the investigation, inquiry, or trial. Key points explained simply. Who can be examined? The accused person or anyone believed to be connected with the offense, such as accomplices or witnesses with direct knowledge. Purpose of examination: to clarify facts, record admissions or explanations, and collect evidence relevant to the case. Mode of examination: the examination may be conducted under oath or affirmation, depending on the circumstances. Proper records of questions and answers must be maintained. Legal obligations: the person examined must answer questions truthfully unless legally exempted. Refusal may lead to penal consequences or contempt proceedings, depending on law. Rights of the examined person: the accused or person examined has the right to legal representation if allowed by law. The examination must be conducted respectfully. What this means in practice: ensures that all persons connected with the offense are examined systematically. Helps authorities establish facts, clarify roles, and gather evidence. Balances investigative needs with the rights of accused and connected persons. Section 111. Recording statements or confessions of the accused. Section 111 explains how the statements or confessions of the accused must be recorded properly during investigation or trial. Key points explained simply. Who is covered? The accused person in a criminal investigation or preventive proceeding. Type of statements: statements made voluntarily by the accused, including confessions or admissions relevant to the case. Recording procedure: statements must be recorded in writing, signed by the accused, and read back to the accused to ensure accuracy. Presence of witnesses: where possible, statements should be recorded in the presence of witnesses or an official attesting authority. Legal safeguards: confessions or statements must be voluntary. The accused must not be coerced, threatened, or induced unlawfully. Statements can be used as evidence in court only if these safeguards are followed. What this means in practice: ensures that accused statements are credible and legally admissible. Prevents coerced or false confessions from being used in court. Protects both the integrity of evidence and the rights of the accused. Section 112. Recording statements of witnesses in investigation or inquiry. Section 112 explains how statements of witnesses should be recorded during an investigation, preventive inquiry, or trial. Key points explained simply. Who can be recorded? Any witness who may have knowledge of facts related to the offense or case. Recording procedure. Statements must be recorded in writing. Signed by the witness, if possible, and read back to the witness to confirm accuracy. Presence of authorized officer. Statements are recorded by magistrate, police officer, or other authorized officer conducting the investigation or inquiry. Voluntary and truthful statements. Witnesses must provide statements voluntarily, without coercion or threat. False statements can be subject to legal consequences. Use in proceedings. Properly recorded statements can be used as evidence in court, subject to verification. What this means in practice. Ensures all relevant witness evidence is documented systematically. Protects the integrity of evidence and prevents disputes about what was said. Balances effective investigation with protection of witness rights. Section 113. Summoning witnesses for preventive or investigatory purposes. Section 113 allows a magistrate or authorized officer to summon witnesses who may have information relevant to an investigation, preventive proceeding, or inquiry. Key points explained simply. Who can be summoned? Any person who is believed to have knowledge or information about the facts of a case. Purpose of summoning. To give evidence, clarify facts, or assist the magistrate or officer in preventive or investigatory action. Form of summons. Summons must be written, specifying date, time, and place to attend, and subject matter of the testimony or information required. Legal obligation. The summoned person must comply unless they have a valid legal excuse. Protection and fairness. Witnesses should be treated respectfully. No harassment or coercion beyond lawful requirements. What this means in practice. Ensures that all relevant witnesses can be brought forward for investigation or preventive proceedings. Helps authorities gather accurate facts to protect public order or enforce law. Balances investigative needs with rights of individuals. Section 114. Procedure if a summoned witness fails to appear or comply. Section 114 explains what happens if a person summoned as a witness under Section 113 does not appear or refuses to comply with the summons. Key points explained simply. Failure to appear. If a witness does not attend court or investigation as required by the summons, the magistrate or authorized officer can take action. Issuing a warrant. The magistrate may issue a warrant to bring the witness forcibly to the court or place of examination. Temporary detention. The witness may be detained in custody until they appear or comply with the order. Legal consequences. Non-compliance without a lawful excuse may lead to penal consequences or contempt proceedings, depending on the law. Respect for rights. Any detention or enforcement must be lawful, reasonable, and respectful, protecting the witness's dignity. What this means in practice: ensures that critical witnesses cannot avoid giving evidence. Helps authorities prevent obstruction of justice. Balances the need for effective investigation with legal safeguards for the witness. Section 115. Manner of recording evidence from witnesses summoned under Section 113. Section 115 explains how the evidence of witnesses summoned under Section 113 should be formally recorded during investigation or preventive proceedings. Key points explained simply. Recording of evidence. Evidence given by a witness must be recorded in writing, noting questions asked and answers given. Details to include. The record should include date, time, and place of recording. Identity of the witness. Names of persons present and any observations by the officer or magistrate. Signatures. The record should be signed by the person recording it and, if possible, by the witness. Accuracy and verification. The witness should be given a chance to verify the record for correctness. Use in proceedings. Properly recorded evidence can be used in court or preventive proceedings. What this means in practice: ensures that witness testimony is properly documented and reliable. Protects both the integrity of the investigation and the rights of witnesses. Provides admissible evidence for courts or preventive actions. Section 116. Examination of witnesses by magistrate or authorized officer. Section 116 explains that a magistrate or authorized officer has the power to personally examine witnesses during an investigation, inquiry, or preventive proceeding. Key points explained simply. Who can examine witnesses? The magistrate or an officer authorized by law conducting the investigation or inquiry. Purpose of examination: to clarify facts, ask relevant questions, and record testimony accurately. Mode of examination: witnesses may be asked questions personally by the magistrate or officer. Answers are recorded in writing and included in official records. Legal safeguards: witnesses must be examined respectfully and without caution. Their identity and presence must be properly noted. Use in proceedings. Recorded testimony is admissible as evidence for investigation, preventive proceedings, or trial. What this means in practice: ensures that witnesses provide clear, accurate, and legally reliable testimony. Magistrates have direct control over examination, preventing miscommunication or errors. Protects integrity of evidence and rights of witnesses. Section 117. Examination of witnesses who are unable to attend personally. Section 117 explains how a magistrate or authorized officer can examine witnesses who cannot appear in person due to illness, distance, or other valid reasons. Key points explained simply. Who is covered? Witnesses who are sick, elderly, detained elsewhere, or otherwise unable to attend the place of inquiry or court. Mode of examination. The magistrate may visit the witness or allow examination via authorized representative or use other lawful means to record the witness's statement. Recording procedure. All statements must be recorded in writing and include date, time, and place. Name of the witness. Questions asked and answers given. Signatures or marks of witness if possible. Legal validity. Statements recorded in this manner are admissible in court, as long as proper procedure is followed. Protection of witness. Witnesses must be treated with dignity, and their rights must be respected during the examination. What this means in practice: ensures that critical witnesses are not excluded from proceedings due to inability to appear physically. Helps authorities gather complete and accurate evidence. Balances investigation needs with witness rights and convenience. Section 118. Examination of witnesses who refuse or evade examination. Section 118 explains the legal consequences and procedure when a witness refuses or tries to avoid giving evidence during investigation, inquiry, or trial. Key points explained simply. Refusal to testify. If a witness refuses to appear or refuses to answer questions without a valid legal reason, the court or officer may take action. Issuing summons or warrant. The magistrate may issue a summons or, if necessary, a warrant to compel attendance. Detention until compliance. The court may detain the witness temporarily to ensure they comply with the summons or order. Legal obligation. Witnesses must cooperate unless protected by law, for example, privilege against self-incrimination. Respectful enforcement. Enforcement must be lawful, reasonable, and respectful, without unnecessary force or harassment. What this means in practice: prevents obstruction of justice by uncooperative witnesses. ensures that investigations and trials are not delayed, balances the need for testimony with the rights and dignity of the witness. Section 119. Examination of witnesses who are minors or otherwise vulnerable. Section 119 explains how a magistrate or authorized officer should examine witnesses who are minors, disabled, or otherwise vulnerable, ensuring their protection and comfort during the process. Key points explained simply. Who is covered? Witnesses who are children, minors, persons with physical or mental disabilities, other vulnerable individuals needing special consideration. Procedure of examination. Examination must be conducted in a manner appropriate to their age, understanding, or condition. Questions should be simple and clear. Presence of support persons. A parent, guardian, or appropriate support person may be allowed to be present during the examination. Recording statements. Statements must be recorded carefully, noting the witness's age, condition, and manner of responses. Can include audio or video recording if required for clarity and legal validity. Protection of rights. Witnesses must be treated with dignity, and the examination must avoid intimidation or trauma. What this means in practice. Ensures that vulnerable witnesses can give evidence safely and reliably. Protects children, disabled persons, or others from stress or harm while preserving legal accuracy. Balances justice needs with humanitarian treatment. Section 120. Manner of recording evidence of vulnerable witnesses. Section 120 explains how the statements or evidence of vulnerable witnesses, like minors or persons with disabilities, should be formally recorded and preserved for use in investigation, preventive proceedings, or trial. Key points explained simply. Recording procedure. Statements of vulnerable witnesses must be recorded in writing, clearly capturing. Questions asked, answers given, and observations about the witness's condition or understanding. Verification. Where possible, the witness should sign or mark the record, or confirm orally that it is accurate. Use of technology. Audio or video recording may be used to preserve clarity and reliability. Presence of support persons. Guardians, parents, or legally authorized persons may be present during recording to provide comfort and protection. Legal admissibility. Properly recorded evidence can be used in court, maintaining credibility and protection for vulnerable witnesses. What this means in practice. Ensures vulnerable witnesses' testimony is accurate, reliable, and legally valid. Protects the witness from trauma or misunderstanding. Balances effective justice with protection of rights and dignity. Section 121. Recording evidence of hostile or uncooperative